Okay, good morning, everyone. I'm Jamie Baker, and because I'm the chair of the Standing Committee on Law and National Security at the ABA, working along with Harvey Rishikoff, who is essentially co-chair with me, we rotate like Putin and Medvedev. We rotate positions every couple of years. And
who's Putin?
He's Putin.
Nice.
But because of that, it's my honor to open the conference. This is the day. This is the 6th annual Jirga. We took a poll beforehand to figure out how many there had been. And a couple of the folks in the room have been to all 6, so it worked out that we could get the right tally. I've also taught national security law and do teach national security law at various law schools, including Yale, Georgetown, Iowa, Pitt, and WashU. Now, before making a couple of comments about teaching cyber law, I did want to do one thing, which is to recognize and thank Bobby for putting on an awesome conference. I know that you've found a home in Austin, both intellectually as well as for your family, and you've made all of us feel very much at home during the past couple of days. So it's been a fabulous conference. Yeah. And so I don't have much for you, but in the time-honored military tradition, I have for you the much coveted ABA 50th anniversary of the committee. So this is going to be one day a collector's item.
It's one of a kind.
And you'll have to wait another 50 years to get something like that. So
appreciate the time. Thank you.
Woo! Okay, just a couple of comments, and I'm obviously not here to tell you how to teach cyber law. Quite the reverse. Thank you very much. But what I would like to say is law schools spend a lot of time training people to think like lawyers. Everybody says, oh, we're training them to think like lawyers. They spend far less time, and some would say way far less time, too little, training their students to act like professionals, which is to say members of an honorable profession. And this is represented in current educational field in grade school by putting emphasis on EQ as well as IQ. And as far as I can tell, law schools spend all their time working on the IQ side of the equation. Professional responsibility is taught on your way out the door. It's the last thing you do, and then they say, please pass the, whatever the ethics thing is, so we don't look bad. Professional responsibility and ethics should be the first course you take at law school, not the last, because it should frame all that you do, not only in law school, but as a professional lawyer. And therefore, my pitch for you today is not just to think about the substance of cyber law, but to think about how you can frame that substance in a way that will get law students not just to think like lawyers, but to act like professionals. And here are some of the things that I think professional lawyers need to know beyond the substance of the law, in this field as well as more broadly in national security. One, of course, is technical confidence and competence. Technical confidence and competence. Competence is an essential lawyer trait, but what I'm really after here is the confidence to deal with technology that's breaking in a new way every day as they go forward. It's less important that you know how to deal with the technology of today, but like a 10-year-old or a 15-year-old, you can pick up any device in the future, or any code in the future, and feel comfortable with it. Professor Paul Ohm is doing just this with his course at Georgetown teaching code. And it was supposed to be a small course, and the waiting list was 120. So the market, the students know what they need in this area, but what I'm extracting from it is not the competence to write code, but the confidence to deal with technology. The next thing is procedural knowledge. And in cyberspace, the pathologies of national security in particular are more pronounced even than they are in other areas. The pathologies are things like secrecy, speed, the national security imperative, the desire to get the yes to protect national security, and the thing that I call the Jackson principle, which is the focus of the government on the immediate problem, the transient problem, to the loss of the enduring consequences of their actions. That's classic government behavior. There's nothing wrong with it if you spot it and say, but what are the enduring consequences? But think about it, in the national security space and in the intelligence space, you have incomplete facts, there's a lot of secrecy, things move very fast. In cyberspace, that's all multiplied sometimes. So you have to be even better at spotting the pathologies and dealing with them. The core lawyer skills remain the same. Core lawyer skills like critical thinking, being able to communicate complex concepts succinctly and clearly. And here, that's particularly important because now we're crossing cultures. We have technical people, we have policy people, and we're dealing with a new body of knowledge for many people. So the lawyer has to master the ability to clearly and succinctly present the information. Don't lose sight of that essential skill while you're teaching cyber law. History. I'm constantly amazed at how my students don't know basic history. You're teaching a course on covert action, and they've never heard of the Bay of Pigs. You're teaching a course on federal courts, and they've never heard of the great civil rights judges like Frank Johnson or Albert Tuttle. It's not their fault. It'd be their fault if 80% of them knew and the other 20 didn't, and what's with that? But essentially 100% don't. And as our speaker last night, Mr. Bankson said, I don't have quite the right words, we're the plank owners of this field. It's a new field. We get to establish the laws, the principles, and guess what we're doing now? We're also writing the history. And make sure your students know the history they need going forward. Why? Because history puts things in perspective, right? The student's going to say, or the young lawyer's going to say, this is the worst cyber thing I've ever seen. George Marshall's going to say, I've seen worse. This is nothing. Calm down. And they're going to know if you hack back, a small act can lead to large consequences. So history is essential. Two more. Intelligence. Right? How can you have a debate about metadata, about 215, 702, or anything else without knowing the difference between actual intelligence and raw intelligence, or how the government uses intelligence? And I'm struck here by the fact that there are any number of federal judges are generally viewed as omnipotent, and I'm living proof of that. But I was surprised in the context of 215 how many judges didn't get what intelligence is and would write things in their opinions like, well, the government has not shown us that this program has ever prevented a terrorist attack, therefore it's not necessary. That's not how intelligence works. And if you're going to work in the cyberspace, you need to understand how all this data comes together, how it's used both to identify patterns, identify areas to pursue, and indeed to take people off the interest list as well. You don't have to agree with it, you need to understand it. And then finally, cultural awareness, right? And in this area, and at your conference, we've been exposed to a wider range of skill sets, styles, and ages than at any of the previous Jirgas, because we're dealing with cyberspace. And that's wonderful. It makes it a joy to be in this space, but it also means lawyers need to be all the more cognizant of how their personalities may be affecting things, and they have to understand the culture in which they're operating. By that I mean, if you are a king and you say, who will rid me of this meddlesome priest? The knights hear it, and they say, I know what I'm going to do. We're going to ride down to Canterbury Cathedral and chop up the bishop. A Marine hearing that would set up an ambush zone and wait for the bishop to ride through the ambush zone and then kill everything within the kill zone. A CIA officer will recruit someone to go blackmail the bishop or perhaps sleep with him so that you can force him out of the position. A diplomat will hold an international conference, discuss the ramifications of the possibility that the bishop might be removed one day. The cyber person is going to write code to hack into the bishop's computer and try and get him to collapse that way. So the lawyer advising each of those people have to know how their advice is going to be heard and rendered, lest you end up with the 4 knights going down to the cathedral when you didn't intend it. So that's very important to understand as a young lawyer, how are my words going to be received by this audience? And this audience is going to be a number of different people, not just the cyber person, not just the senior lawyer. So in closing on those comments, those were a number of skill areas, EQ areas, as well as knowledge areas that anybody practicing in this area ought to have and command. And my charge and challenge to those who teach cyber law is to not just teach the substance of the law and not just to produce the next and first generation of cyber lawyers, but to produce the first generation of professional lawyers working in cyberspace. That's what we're after, professional lawyers. So, thank you, and I look forward to hearing everything. Thank you very much.
Okay, so we're going to switch and begin the first session. As I think everybody knows, we are collapsing what originally was meant to be separate discussions of the substantive and procedural criminal law aspects of cyber, then a distinct session on intelligence, surveillance aspects of cyber from the intel and national security side. We're collapsing it into one for reasons of convenience involving travel of our guests. So without further ado, what I will do here is quickly introduce everybody, and both Bill Banks and Paul Ohm will be going first in sequence because they're going to have to slip out in a little bit, and then the rest of us, Sean, Richard, and Jen and I will continue the conversation. So we will be bouncing a little bit back and forth between the criminal side of the house and the intelligence side of the house, but I actually think that there's a certain logic to that. Okay, so Bill Banks from Syracuse, Jen Daskell from American, Richard Downing from the Computer Crimes and Intellectual Property Section at the Justice Department, Sean Farrell from FBI, Paul Ohm from Georgetown. Paul, why don't we start with you and share your thoughts about the baseline fundamental pedagogical question that branches across all of the topics today.
Yeah.
You have a bunch of JDs that walk into the building, or would-be JDs, and you can't assume any knowledge, although some of them, they're digital natives, you can't assume technical knowledge. What do we need to teach them?
Yeah, so thank you so much. And this is my 11th year teaching, and this is the first time I've ever had an entire day on pedagogy. So I credit this ABA section so much for doing this year after year, and I hear, Harvey, that you're a large part of why, and so I forgive you for the mistakes you made in our debate yesterday. I'm just kidding.
And for your Putin-esque quality.
And your Putin-esque quality.
Did we say ethics and etiquette?
And Judge Baker, those were inspiring words. I wrote them all down, and I'm going to really take them to heart as I think about this project going forward. Okay, so what is my project? If you'll let me indulge a little bit in 2 minutes of biography, and I could talk about this for 3 hours. I'm going to try and compress it to 15 minutes, and apologies, I have to run off to the airport soon. I have undergraduate training in computer science, and one thing I've been thinking a lot about is what is it that makes the courses I took as an undergraduate different than law school courses? They're different in so many profound ways, and I've been exploring which of those techniques, subject matter, approaches could be imported into the law school environment. I've been doing this since I became a law professor. I'm also informed by a 2-week course CSIPS sent me to when I was at the Justice Department, which was called Scitex. Do you still send people to Scitex? I don't even know if it's a going venture. It was hacking school, and so we were each given a Linux terminal, and we were given 2 weeks to learn how to find malware, deploy malware, do exploits. And the best part of the class for me was me and one other student realized quickly how vulnerable the class server was. Assuming we had consent, we hacked into the server and started communicating with one another in a back channel. And at every break, the professor would say, "Okay, do this work," and then he would run, and his shirt was increasingly disheveled, and his hair was getting all messed up, and he was just pounding away on his keyboard, trying to figure out why the lessons weren't working. It was awesome, and it was an experience that, it was not so awesome for him, but it was awesome for me to learn in that way, and it's something I've been trying to replicate without all the stress for the teacher, that is. And then the last thing I'll say is, I'll say two more things. Even as a 3L in law school, I was invited by UCLA Law School, my alma mater, to teach an undergraduate course called the Bill of Rights and the Internet that I designed. This was 1998, right? So it's kind of amazing. And on day one, I came into the classroom with a bunch of boxes with clasps, a bunch of locks, and a bunch of keys, and I made the students figure out public key cryptography logic from the very beginning. So this is something I literally, there will come a day soon when my students will be, will be able to say, I've been doing this since before you were born, right? And that day is coming soon, which just means I'm old. Okay, so what am I talking about? As Bobby said, I'm thinking about new ways to teach technology to future lawyers, and I've been doing this for many years. The overarching philosophy, I'm going to talk about overarching philosophy, some courses I have so far, and the lessons I've learned. Here's my overarching philosophy. We too often teach law and technology in law schools. We too rarely teach technology and law. Here's what I mean. Here's what happens in lots of law school classrooms. I think there's no problem with this. I think there has to be a lot of this. You're teaching a case or a body of law that turns intrinsically on a technology. So you talk about the cases, you walk through the cases, and then you say, oh, by the way, there's this thing called an IP address that you need to understand. Let me spend 10 minutes telling you what an IP address is, how it works, and why it might be important. You do this digression. It feels like an aside, and then everyone takes a deep breath, and you're like, all right, let's rush back into law land where we're warm and comfortable, right? I want to invert that paradigm. I want to teach a class, and I have taught classes, that are technology classes almost entirely for law students. And I unsettle them on the first day by saying, you may not know why this technology is relevant to any particular law or policy question. In fact, you may end the semester not really being clear why some of the pieces matter. Every so often, we'll do a digression into law, where I'll say, oh, by the way, there's this case called Smith v. Maryland, and it turns a little bit on what we've been talking about. But then we'll rush back into the warm embrace of the technology, right? And so this is what I've been trying to do, and by being self-conscious and explicit on the first day, my students understand what I'm trying to do. Overarching philosophy number 2, deep technical knowledge is the name of the game. Every student has their hands-on keyboard for every minute of every class. We use real tools by real professionals. We're using Wireshark, not some kind of abstracted example of a packet sniffer. We don't use simulations. We don't use dumbed-down versions, which, of course, is a teaching challenge to deal with infrastructure, to deal with student laptops. And I've thought a lot about that, but that's not the focus of my class today. Of my talk today. Okay, lastly, on the overarching philosophy, I have tried, and this to me is going to be my career-long project, I've tried to identify the skills, the knowledge, and the moves that mark successful practitioners at the intersection of tech and law. So I think, this is what I think. I think, okay, people like Ed Felton, Ashkan Soltani, Chris Sagoyan even in my space, what is it that they know, what is it that they do, what is it that they understand that makes them successful? But even more importantly, I look at lawyers who did not start out as technologists but are thriving, lawyers like Richard Downing, Rick Salgado, who's now at Google, Todd Hinnon, who's at Perkins Coie. I think it's no accident that all three of those lawyers were trained at CSIPs. The word I like to use is, I ask, what is the playbook? What do they know that's implicit knowledge that they've learned that nobody's ever written down or tried to kind of bottle and then redistribute? And again, this is a career-long project. I imagine I'll have books on the playbook at some point. Some of these are airy philosophical abstractions that only a law professor could love. So I teach my students about Lessig's Code is Law, Harry Surden's Structural Rights and Privacy, or Kerr's Problem of Perspective. If you don't know the latter two, I'm sure you know Code is Law. Read those papers. They're essential papers in this space. But more importantly, I've realized that there are concrete skills that really aren't taught in a systematic way. They're taught in every law school class, but not in a systematic way. So Richard, I don't know if you still do this at CSIPs, but this was my interview to work at CSIPs. It was a half-hour interview with 3 or 4 attorneys, probably the most intense interview of my life, even more than these crazy law professor interviews that are kind of famous. I walked into the room. I don't think we even had pleasantries because, frankly, CSIPs has a lot of socially awkward introverts. And question 1 was, give me an analogy for mail. for email. And so I said, well, it's a little bit like physical mail. There's an envelope. And they're like, okay, tell me why that analogy is wrong. And I'm like, okay, well, it misses the point because packets, at the line level. And they're like, okay, give me a counter analogy for mail. I'm like, okay. And we did this for literally 15 minutes. Only after I arrived at CSIPS did I realize they understand that that's all they do. Every single day of their job is they try and craft or critique or tear down analogies. So I do this with my students. One of my graded assignments in one of my classes, which I'll get to in a second, is pick a complex technology and write an analogy to describe how it works, and then write the other side of the brief that tears down that analogy, right? Again, making explicit, which I think up till now has always been an, oh, by the way, this is a useful thing to know how to do. This is why I think these courses need to be taught in law school. This is why we can't just outsource this training to computer science departments, because they don't understand the playbook, right? It's a different subset of technical skills and learning that I'm talking about. All right, let me give you 2 practical examples. The first I'm going to spend very little time on because the jury is still out, but it's the one that Judge Baker talked about. So in December of 2015, a couple of months ago, a colleague said, Paul, you should teach computer programmers how to code. I have tenure, so I am willing to take on an extra class that I don't get credit for. I'm like, yeah, let's do it. We proposed the class December 15th. It was added to the catalog December 18th. December 19th, I told 2 student groups about this. December 22nd, 120 students had signed up for the class, which was a problem because we had 15 seats. So I'm now in my 4th week of teaching Python to lawyers. The assignment that they're struggling with this week is build a text adventure game like Zork from the 1980s. Right? I give them 100 lines of code that barely work, and they have to add an inventory system and a monster system, and it's just been both the hardest teaching of my career and the most fun I've ever had teaching. And if you want to ask me a few questions later, I can talk about why I think lawyers need to code. That's another hour-long lecture I could give you. Okay, but the class I think that will be much more directly relevant to what a lot of you do in this room. For 4 years, I've taught a class called The Technology of Privacy, which embodies all of these philosophical approaches I've talked about. Lesson 1 of this class, I'm going to tell you lesson 1 and lesson 2. Lesson 1 is I walk into the class, again, without ceremony, I don't even do any introduction. I hand out an encrypted text, and I say, we're going to work on deciphering this. Now, it's ROT13 encoded, so it's not really encrypted. All of the letters are just rolled 13 away, so A becomes M, etc. I usually try and pick something that's really topical. So one year it was Edward Snowden's Christmas message. The next year it was my colleague Paul Campos telling law students why law school is a fraud. And so it's just an amazing 15 minutes of discovery as one student realizes, oh, the single letters are I's or A's. The thing after the apostrophe might be a T. It's so fun. And in that 2-hour lecture, we get through symmetric encryption, we get through the Vignere cipher, and again, we're doing this in a deep, 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 deep way. I've actually learned that you can't do symmetric and public key crypto in one day. It's just too hard. So I put off public key for a later class. Week 2, the laptops come out. And week 2, and this is, again, not national security, but I study consumer privacy quite a bit. So we do an entire day on cookies. And cookies lend themselves to a really amazing classroom experience. Number one, you don't need to know what an IP address is to understand how cookies work. And so let me just tell you, this might just be illuminating or illustrative. Let me tell you the 5 steps we take. Number 1, there's a panel in your browser that lets you observe your cookies. Do it. I don't tell them how. After about 5 minutes, they all find it. And I say, okay, how did you find that panel? How difficult was it? How many clicks did that require? And what kind of social or legal choices went into the design and engineering of requiring you to click 5 times to view your cookies? Step 2, open up the cookie panel on the right and your browser on the left, and keep clearing your cookies and visiting websites to see which cookies are set, which are erased, what the expiry time on those cookies are, etc. And we have a game to see who can find the website that sets the most third-party cookies. It's usually a travel website or a deals website, although we've had years where it's something else. Step 3, visit the Blue Kai registry. If you haven't done this, I highly recommend it. The Blue Kai registry, Blue Kai is one of the big ad networks, and they will tell you, here's what we think you are. Here's what we think your income is. Here's what we think your part of the country is. We think you're shopping for a car. We think you want to travel to Aruba. And they tell you all of that just by looking at your third-party cookies. Step 4, opt out of cookie tracking. Again, I give them no instruction. I'm like, just opt out of it, right? And for anyone who's ever looked at that question, that is a comical 15 minutes. Your student's like, what the do I have to do, right? And at the end of that lesson, of course, as the coup de grace, I say, oh, by the way, the next time you clear your cookies, all of that opting out you just did will be wiped away. So, of course, this leads to our first, oh, by the way, there's this whole law and policy debate about something called do not track. You now know enough to contribute to that debate. Here are the basic contours of the debate. We have a little bit of the debate. And just when they're feeling comfortable because we're back in law land, I say, okay, we're done with that. Let's go back to the next lesson. And then step 5 is basic browser forensics, right? Let's look at cache. Let's look at your history. Let's download a few forensic tools to look at these things in a little more detail. All right, final project. The final project in the class is to pick a website or an app. This is a seminar, so there's no exam, and to conduct a third-party privacy audit. So essentially, I teach the students how to wiretap themselves using Wireshark and an amazing, amazing tool for teaching called MIDM proxy, man in the middle proxy. If you have not played with MIDM proxy, you really ought to go do it. Commissioner Sweeney of the FTC spent her whole summer MIDM proxying all the websites she was visiting. It's really easy to use. And so these students, and by the way, I should have said this at the outset, I take a poll on the first day, and half the students, and to be quite candid, most of the women say, I have no prior technical experience, I'm terrified of this class, but I still think it's important to learn it. On the last day of class, each one of them goes up there and they say, okay, here's what I learned from Wireshark, look at this odd packet header, look at the third-party tracking that isn't occurring through cookies, right? And the funny thing is they don't know what they don't know. They don't realize how exotic their particular learning has been, but they're masters at it by the last class. Okay, what are the lessons? And then I'm going to cede the floor. Lesson 1, Judge Baker nailed it. You said exactly what my first lesson was. I'm not teaching them any particular set of technologies because those will change tomorrow, right? I'm teaching them how to think about learning technology, and I'm demystifying it. I'm trying to teach them you too can do this in a continuing way. And so it's funny, I present this talk a couple of times to audiences, and they say, oh, why aren't you teaching them cloud architecture? That's the only thing that matters. I'm like, I don't care what I teach them. Like, I could almost pick 5 topics out of a hat because it's that other how to learn skill. Number 2, if you haven't followed me on this path yet, and you're going to, you will be surprised what your students don't know, right? I had a student, 3L, I think ranked 4th in her class, not at Georgetown, at Colorado, where I came from. I taught an entire day on Excel in a statistics course I taught, and she walked up to me at the end and said, Excel is the most useful thing I've ever learned in law school, which was both really inspiring but totally terrifying. And so every year I ask students, I say, how many of you have mastered Excel? And it makes me fear for elementary school education in our country that half my students really don't know Excel by the time they get to law school. Number 2, on a related vein, they don't understand their file system anymore. Students save things to the documents directory, but the idea that there's a tree hierarchy and there are folders, for some reason that knowledge is getting lost on the younger generation and something we have to spend 15 minutes doing. I spent 20 minutes 2 days ago in my programming class teaching students what the remainder was in division so we could do modulo math. And I swear a few of them just had no idea what I was talking about. I'm like, anyway, no more about that. And for some of your students, this may be the most important thing they get out of the class. It hopefully isn't the only thing, but it may be the most important. Last 2 things I'll say. One is, what are we going to do next? So I have these 2 courses. The Dean of Georgetown has asked me to generalize this, to create Technology for Lawyers Bootcamp, a 1-week class, an elective for 1Ls, something that can scale up to 200, 300 students. So we're starting to plan for that. Topics I have to teach them, and it's going to be far less deep. Data visualization, Excel, browser forensics, e-discovery, cybersecurity, and then basic, here's how your computer works. So I think we're going to try and launch that next school year. Last but not least, I've now given a talk like this to a very different audience of practicing lawyers, and at the end, 8 of them came up to me and said, okay, I want to take this class. And so I am thinking about how we might break out of the law school and maybe set up CLEs around this, or maybe, and especially in DC, where I think it's hard to practice in DC and not know this stuff. I'd love to find ways to package pieces of this and bring it to a broader community. All right, I really apologize. I'm not going to be here this entire day. I'm dying to know what the rest of you say. Will this be archived on
will
video?
be.
All right, I'm going to watch the video, but thank you for indulging me, and I appreciate your time.
Thank you, Paul, and we'll have to bear that in mind once you're gone. Normally, people leave early and you start talking about it, but since we are recording, capturing audio and video, and you're intending to watch it, we are on notice. Exactly.
I appreciate it.
We're still going to do it. We'll be mindful, we'll be more targeted. So,
Paul, I'll just say, if you wanted to create a series of videos
Yeah.
based on the lecture,
Yeah.
based on the presentation parts of those, we could create a home for that.
Cool.
Yeah.
I appreciate that.
There
yeah.
you go.
Yeah.
Wants to know if you're going to charge.
yeah, well,
Based on yesterday's conversation, right?
I
Charge
can
for
guess your
intellectual
answer,
property.
We'll talk about the ABA, we can help you too.
Good, good. Thank you, guys. Thank you. I appreciate
fantastic.
that.
Okay, that's inspiring, and we're off to a great start. So now we're going to begin turning it a little bit more towards particular law school subjects.
Thank you.
And we're going to start with Bill Banks to talk about the intelligence side of the house, the collection side of the house, and the pedagogy of teaching topics such as surveillance law, which is such a sweeping area, and it mixes technology, policy, and law in such a complex way.
Right, yeah, I'm going to sign up for Paul's class. Or if we can clone you and send you around to all our schools, but I think that the lawfare idea, the ABA, that's great. So the program yesterday, first thanks to Bobby and the Strauss Center. Yesterday's program was just fabulous. 4 panels, cutting-edge issues, integrating tech policy and law. We couldn't have asked for more, it seems to me. So last night, talking with some of my law professor and lawyer colleagues, there was a sort of a common lament. And the lament was, there's no way we can keep up. There's no way we can know it all. The field changes so fast. There's so much demand among the law trained to keep up in the ways that only people like Paul Ohm perhaps can keep up. And most of us are teaching, more sort of mundane subjects across the curriculum and have to find a way to embrace what we learned yesterday in a field that we ourselves can't manage to keep abreast. So what's the objective? I too, Paul went back to Jamie, and I think it's about principles, enabling students to understand some common themes and issues, making them appreciate that they're multifaceted, increasingly dynamic, and they'll need to work well beyond traditional legal doctrine and tools to know what's going on. You can't be competent. You can't be equipped as a lawyer if you do. So even in a national security law course, which you would think might be all over cyber, and where cyber has become a big deal, there's so many choices to make about what you might say, what you might cover, and in how much depth. I think there's some good courses that focus heavily on the intelligence side of national security law and may deal with cyber quite heavily. I'll say a couple of words about that. But there are other courses in national security laws, as many of you here in this room know, that might not even deal with intelligence. It's simply, national security law itself is such a broad, big, complex field these days that choices have to be made. So maybe the starting point for dealing with cyber in a course that does focus on intelligence and surveillance is that cyber law and policy and surveillance law and policy might be viewed as sides of a coin. They're really inextricably interrelated. You can't understand one without the other. And if you can convey that much to your students, you might have achieved something. Just think about the panels yesterday, going dark and encryption. It's all right there. And the second one on research, similarly, it's surveillance and cyber wrapped into one. Maybe the second, the third and fourth ones in the afternoon were less directly about intelligence and surveillance, but even those, you rely on surveillance capabilities and legal limits to get at the problems that you were investigating on hackbacks and botnet takedowns. So our students can't begin, of course, to fathom how the world of intelligence and surveillance has changed, even in the 15 years since 9/11, much less appreciate how the change in these 15 years dwarfs decades of evolution of legal doctrine that came before 2001. I don't need to remind you what that's all about. Many of you know that far better than I do. because the internet and digitization are largely unregulated in their development and software systems are so fragmented, the same methods that law enforcement and intelligence community agencies use to keep us safe may invade our privacy, steal or compromise things of value. So teaching about cyber and teaching about surveillance are inextricably bound up. Again, the going dark encryption debate is emblematic of that phenomenon, and I can't think of a better one in which to impress upon your students how the two fields are interrelated and how you have to know something about cyber to understand surveillance. It seems to me at our schools, what we actually do in our courses may depend as much as anything on what's in your curriculum. If you're at Georgetown, the sort of gold standard here, you can have Paul Ohm doing 2 courses like the ones he described and still have room for, 25 other courses in the area of national security. My mouth waters every time I travel down to Capitol Hill. It's just an incredible phenomenon. Most of the rest of us are in more modest institutions with less capabilities. Even here at Texas, where you've got all these wonderful resources, what do you have, 3 or 4 courses maybe across the curriculum that touch these areas?
Well, since we're adding Steve Leddick, hello, Steve.
Yeah.
We're adding Steve, so
Yeah.
that brings like 9 or 10
9 or
courses
10
a
more
semester.
courses. Right. So, in my own school, we're fortunate enough to have someone who does a cybersecurity law and policy course. And I'm talking with Kristen and with Eric and some others in the room. It sounds like there are a number of schools now that are offering such a course, maybe on a regular basis, independent of a national security law course. That's great. So in your national security law course, you can do something like what I just said. You could do going dark and encryption and feel like, your students who are more interested in cyber can take that course as well. Seems to me, for those in a national security law course where you're going to do an intelligence unit and you want to say something about cyber, one way to level the playing field is to bring in Paul Ohm. If you can't bring in Paul Ohm or get him on video, another is to assign some background readings. And I don't know, is Andrew here this morning? I don't see Andrew. Maybe the best thing I know of for a primer, oh, no, not this Andrew, the author, with Pete Singer. The book that Pete and Andrew did that's called something like Cyber, What Everyone Needs to Know.
I'm about to say nice things about it, I'll take it.
All right. There were 3 authors, actually, Andrew Woods. I don't think so. But it's a great primer. If you haven't read it, and it's widely available, it's accessible, I think it's in paper, and the discrete chapters in there, you can get your students to read some of the chapters, and they'll at least have a common denominator level of knowledge you can assume in a course like that. In a survey course that covers intelligence and surveillance and national security law, it depends on the materials you use, of course. I know a good casebook that focuses pretty heavily on the intelligence and surveillance. It has 7 or 8 chapters in a forthcoming 6th edition that will give you, 5-6 weeks worth of heavy teaching that builds all the surveillance law, including the structure of the intelligence community, and deals with things like covert action and the like that are a little bit outside the immediate topic for today.
Can I interrupt you to ask you to elaborate a bit? So you and Steve Dykes and Peter Raven Hansen, Steve Leddick, you guys have this fantastic national security law casebook, but you also have the counterterrorism narrower version. For people who are interested in this topic in particular, does it make more sense to go with one of those books versus the other?
If you're interested in intelligence and surveillance as a core part of the course, I'd use the National Security Law book because it includes the chapters on the structure of the IC, the basic legal framework for intelligence organization as well as collection, and then it has the separate covert action material. The CTL book, I think, focuses as one of those chapters, but then goes right to FISA and bulk collection and the
And you're
like.
raising your royalties on both of those.
I rethought that overnight.
You got a question?
Oh, yes.
Yes.
Yes, Vicki.
Yes, since intelligence law is really a subset of national security law, it would be helpful, I think your publisher is willing to sell those chapters, because that's kind of the trend. And there's no real one book on intelligence law. You have to take chapters from national security tax.
Yeah.
So it'd really be helpful to be able to make those chapters separately, and publishers are doing that all the time. If not, you're going to get the fair use, I'm going to copy your chapter.
I was asked by somebody who was on the live stream yesterday to be sure to repeat or summarize questions that come out of the audience. And so the question was, is it possible with your Aspen books, does Aspen allow for individualized chapters to be broken out for purchase or use?
Yeah, I don't know the answer to that, but there is I think that question is being asked with more frequency of the publishers like Aspen now. And
I would suggest you ask them to do that.
yeah, no, I think it's a good idea. And I think packaging, Bobby and I talked offline a couple of mornings ago about the way you might do a course in national security law that just covers the intelligence. You could really do 3 hours, or another one that just did detention and interrogation, another one just did IHL and ad bellum and so on. So it's impossible. When you see the new edition of our book, it'll be 1,400 pages, 1,500 pages, and we've tried to simplify. You know how difficult that is. And we'll also do a teacher's manual, of course, which will make some suggestions for using parts of the book. And I have heard, I can't verify it, that sometimes chapters are copied. Yeah. Why don't I pause there?
Okay, great. Well, you and Paul need to go visit
Yeah, I'm
the airport.
sorry, too, that we can't stay around for all this, but I'll look at the archive.
We appreciate you both being here. Thank you very much.
Thanks a lot.
We'll give you a second to clear out, and then we'll
Okay.
stay in place in order.
All right, perfect.
Sit down.
Thanks.
So, sorry, everyone. No worries. So for those of us who are on the now rump panel, let's continue right where Bill and Paul have set us up. Maybe talk a little bit about the nuts and bolts. Why don't we, since we're on the Intel side, Jen, let's stay there for a second. And can you share some thoughts about how you structure? You teach Crim Pro, substantive criminal law, national security law. So you have multiple classes where you could cover these topics. Where do you choose to approach it, and how do you choose to approach it?
Right. So thanks, Bobby, and thanks for a terrific conference. So I mean, I've actually tried and struggled with trying to incorporate some of these issues in both my basic 1L Crim class and also my Crim Pro class, where I teach is mandatory for all 2Ls, second-year students. And it actually doesn't work that well. There's too much to cover that's really kind of the fundamentals that this, and really understanding the fundamentals is critical for being able to analyze all of these issues. And so I actually don't recommend trying to kind of jam this into either of those courses. In my Crim Pro class, I do spend some time on the third-party doctrine, and I think that's a place where you can, we talk about Smith v. Maryland, we read Miller, we talk about the third-party doctrine, we talk a little bit about Warshak and the difference between content of communications and non-content, but it's a very small kind of sliver of the class. And I actually think that's appropriate. I think that's right. There's just so much to cover that's the basic fundamentals that I don't recommend trying to incorporate a lot of these kinds of sexier, more really interesting and exciting issues in those core classes. I also don't have the luxury of teaching a class that's just devoted to these issues. I teach a national security law class that used to not have any sort of surveillance or cyber issue incorporated into it. And now I've tried to condense that class and tack in a few classes on cyber and intelligence. And it's really hard. I've struggled with it. I've struggled with how to do it right. And my answer where I am right now is that it doesn't really, I've tried to teach FISA, I've tried to teach the FAA, I've tried to have them read the rules, I've tried to have really interesting debates about 702 and PRISM and upstream, and it's hard. It doesn't work. It's too complicated. And where I've ended up is really kind of going back to the fundamentals, and even though they've all taken Crim, even though they've all taken Crim Pro, spending a class kind of working through the basic, I think, foundational concepts and the foundational cases. So talking about Verdugo and the concept of a territorial Fourth Amendment and what that means for our entire surveillance structure. Talking about Smith v. Maryland and Miller and the third-party doctrine, and also reading Jones and thinking about the evolution of the law in that way. To the extent that we talk about FISA, which I am doing in this class, we read the INRI directives case and the analysis of the PAA, the precursor to the FAA, and think about the issues that raises. And I also do a class devoted to 215 and to Clapper and Clayman, not because I think 215 is a particularly important program. I don't. I think it's actually a relatively irrelevant program. But I think those cases and those issues and those debates really kind of crystallize some of the key concepts that students should struggle with and think about. What's the meaning of relevance? How do you think about intelligence collection versus criminal law collection? I forgot to mention Keith. That's another key foundational case that I think everybody should read.
You know, I want to jump in on something you said, because I've struggled in my national security law class, which, you know, it's a 4-credit class, which is a luxury, so you have endless meetings. I would say 14 years ago, there was just a very brief amount of surveillance, some basic FISA stuff. And then and you'd have a huge amount of attention 12, 14 years ago on the detention, and lots of classes on habeas and Boumediene and so forth, or the pathway to there. And then over time, the detention stuff began to get compressed, and the lethal force stuff began to get bigger. And then, so around maybe for some reason the summer of 2013, suddenly the surveillance stuff became more pressing. And now I used to have, 3 years ago, there were 4 classes on surveillance. Now I have 14. And so I've decided to really, I've taken a lot out of detention and shifted that allocation. I spend it on surveillance now. But I struggle with the same thing you're describing. I think at least a couple of my students may actually be in here watching this, so they have to be accurate. What I decided to do was to divide that unit between a deep dive into some basics of live capture of content, and then set aside stored communications and set aside metadata, come to them later, and zero in on the live content side, and actually do a little bit of the history. So I make them learn about the Radio Act and Olmstead, Nardone, the Federal Communications Act, just to kind of get them appreciating some of the backdrop against which later things happen. But the part that I always struggle with, so we build up through time, you get to CATS, Title III, things start to change. The Keith decision is such an endless, it's such a great case. The fact pattern itself and the character of Pun Plamondon is so fantastic. Sets everything up, but then doesn't resolve anything, really, that we currently care about. The Trung case from the Fourth Circuit, I find, is a really great teaching tool, especially because, as I endlessly emphasize to my students, the primary purpose test may be dead within the FISC system because of in re sealed case and in re directives, but it's still out there for people in the circuits to decide that may indeed be what the Fourth Amendment requires. But then the thing I struggle with is trying to convey to the students the impact of disruptive technological change on this, especially the arrival of fiber optic and then the arrival of packet switching technology and communications, and how it complicated what it was that was possible for the government to easily do on the collection side, and how that then led to doing things onshore that didn't used to be done onshore, and how that then implicated 1801 F2 in a way that brought FISA to bear in certain situations. There were some pros and cons to this development for the government. And I realize as I'm up there talking about these technologies, which I probably, in comparison to some of the people like Chris, who was here yesterday, and Paul and you guys, I barely understand. And I think a lot of my students don't understand it at all. And it's almost like I don't know what the right analogy is, but it's not the ideal teaching situation. Do you do anything to try to teach your students anything about the underlying technology and how it's changed over time?
So very, very little, just with connection to the switch between FISA and the FAA and why those debates arose and the development of the PAA, but very little. And I don't have time. I mean, this is like the luxury that Paul has to have an entire class devoted to that. I think you really need, I mean, he's raised a number of questions for me in thinking about restructuring some of what I do, but I don't currently. And I think I mean, there's not enough time to do that and all the other things that I want to cover, like the use of lethal force, some things on detention, some other civil preventive tools that are not lethal force or detention. But at some point you have to make choices, and having the luxury of teaching a class just devoted to these issues, I mean, that seems to be an essential component of what you want to teach as well.
Now, I want to emphasize, because I haven't emphasized it a lot, we expect today to be much more of a roundtable format and encourage more intervention and joining in as we go. So if anyone has anything they're wanting to react to as we go, please get our attention. Anybody? Eric? Yeah. Sorry, I wasn't noticing the telltale.
The Tinto?
Yes.
So the two of you raised a question that I think will probably pervade much of this day's discussion, but particularly in national security law, for example, maybe less so in Crim Pro, where the content of what you're teaching can change so often and change dramatically, like the 2013 Snowden revelations, right? And the question becomes, how do you choose to balance chasing the topic du jour with teaching basic principles that will, you know, somehow survive whatever the topic du jour as it changes? I mean, how do you, I think all of us have to strike that balance. How do you strike that balance?
So my view, I mean, as I said, when I first started doing, I mean, I haven't been doing this that long, so that's a caveat, huge caveat. But the first time I tried to teach surveillance, I went straight into FAA, really important debates about 702, and it just didn't work. So I've come back to the idea that it's more important to teach the basics, to teach the fundamentals, and those. To be an expert in 702, you have to really spend a lot of time in it. To be an expert in this stuff, you have to spend a lot of time reading the statute, parsing the statute, understanding those words, and it's not worth having the superficial conversation. So my view on it is it's worth picking one or two sexy things. For me right now it's 215 because I think it raises, I don't think it's that sexy, but I think it raises a bunch of really interesting issues that is worth playing with the students. And spending a class or two on the fundamentals and then spending a class on one kind of more hot topic where you can apply those fundamentals to a particular sexy thing. But I think trying to do it all, it doesn't, for me at least, it hasn't worked. That's been my experience.
I do try to go into probably more detail in staying current than I probably should. I think in part it's a conscious choice to make it as maximally interesting and engaging for the students as possible to go ahead and dig into the stuff that they've been hearing about. So with 702, completely agreed that it is you could devote the whole 14 days to just trying to get some basic expertise. The PCLOB materials are really great. The Privacy and Civil Liberties Oversight Board, which has generated thus far a Section 215 report that really is kind of a soup to nuts expose, with a cooperative expose, if you will, laying out sort of origins, operation, and really get into the granular details of how things worked and what seems to have come from it. And then they did one for 702. And I spent a lot of time trying to figure out how to take the PDF and chop out the parts I didn't want and get it down to the most efficient subsections within it that seemed to capture the parts that would be most useful in giving the students a granular sense. And so this highlights one of the great overarching pedagogical challenges that all teachers face. By getting down into the weeds and having to wrestle with the weeds, as Paul was saying on the technical teaching side, it's true on the doctrinal teaching side as well, I think. Really forcing someone to think about, okay, so there's a foreignness determination, and you're not allowed to rest on the first report. You've got to look for additional materials. You've got to document your work. There's all this granularity where I ask them to imagine that they're an NSA analyst, and this is sort of their employee handbook, as it were. They're being shown, in effect, what the steps are, dragging them slowly through that process, but then remembering to surface, to come back to the bigger questions and reminding them that you've studied all this historical materials. You know it wasn't always like this, and therefore you know it won't always be like this. So you need that granular experience, but don't dwell on it too much. What you need to step back and see is that the entire apparatus, at any given point in time, from the early 20th century to today, it's an ongoing